one.
Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning.
Good morning, Your Honor.
Welcome to the morning session of the Court of Appeals. Your panel this morning includes Judge Armstrong from Memphis, Judge McGee from Savannah, and I'm Judge Golden from Memphis. As you both know, each side has 15 minutes for your argument. The appellant can reserve up to 5 minutes for rebuttal. I assume, Mr. Nelson, you've reserved some time with the clerk.
I have, Your Honor.
All right, you may call the first case, ma'am.
Jason Britt versus Richard Jason Usery et al.
Mr. Nelson?
Yes, sir. Good morning, Your Honor. May it please the court. This appeal concerns an order.
You need to state your name, even though we all know who you are, for the record.
Yes, sir. I apologize. Adam Nelson, now of the Obion County Bar. Time of the case, I was with Randy Kaiser, Madison County. But I represent the plaintiff and appellant, Mr. Jason Britt. And this appeal concerns an order of dismissal that was granted, rather an order granting a motion to dismiss filed by the defendants, dismissing the case with prejudice. That order was entered August 18, 2020. The appeal also concerns the trial court's denial of the plaintiff's motion to set aside that order of dismissal. Motion to set aside was timely filed under Rule 59, and the order denying the motion was ultimately entered January 8th of 2021.
Nelson, let me ask you a preliminary question.
Yes, sir.
In reviewing the pleadings, we noticed that there was a compulsory counterclaim that was filed by your party. Has that ever been addressed?
It has not been addressed, Your Honor. And if memory serves, I think the counterclaim that you're referring to was a permissive counterclaim. I think it related to something aside from the specific construction that was being done in the underlying case. But to answer your question, no, Your Honor, the case was dismissed outright, and the counterclaim by the defendants has not been addressed. So,
the reason I called it a compulsory counterclaim because that's the way it's titled in the complaint.
yes.
All right, you may proceed.
Yes, sir, Your Honor. So the order of dismissal and the denial of the motion to set aside the order of dismissal are related, but they are distinct legal issues for purposes of appeal. For purposes of the order of dismissal, we've raised essentially 3 issues, although there's some overlap with other issues. The first, and I think most significant, being that it was error and improper for the court to even take up and hear the motion to dismiss that was ultimately granted, because that motion was never properly served under Rule 5 of the Tennessee Rules of Civil Procedure. It's a foundational concept that in order for the court to take up a motion, particularly one seeking dispositive relief, that motion should be served on the other party. The other party should have a fair opportunity to respond and be aware of that it's been filed, 1, and when it's scheduled to be heard, 2. And in this case, that was not done. The rules, and specifically Rule 5, govern service of pleadings after the complaint. Of course, the complaint's more stringent under Rule 4, but everything after that is governed under Rule 5. And in shorthand, Rule 5 allows 2 different methods of service. Generally, traditional service, which is either by mailing it to the adverse party when it's sent to the court, or by hand delivery to that person. That was not done in this case, and there's no argument that it was attempted. That was not the method of service that was utilized. We would submit that there was no method of service that was utilized in this case. The motion to dismiss was, I suppose, an attempt was made at service by email. Rule 5.02 does allow service by email, but the requirements of that rule are detailed and specific, and they are mandatory. It's not a best practices guide, and it's not suggestive. The rule requires and says shall do these certain things. For a pleading to be served by email, it has to include specific language in the subject line designed to notify the adverse party that a pleading is being served. It has to be followed immediately by an actual certificate that has to be hand delivered, mailed, or faxed that's sent to the adverse party that gives the caption of the case, the specifics of the pleading that was filed, and a few other specifics that have to be included in the certificate. And if that's not done, then Rule 5 is not complied with. And the requirements for that are obvious and it's set forth in the advisory comments, but attorneys get a lot of different emails, and we use emails in everyday life, but some, particularly at Rainey Kaiser, I might have gotten 100 emails in a day. If you serve a pleading by email, you've got to, specify in clear language that this is a service of a pleading so that it's not inadvertently overlooked. That attempt at service was made July 13th, 2020, which was a little over a week after the actual motion was filed. The one requirement of the rule is that it has to be in an Adobe PDF format, which this pleading, although it was incomplete, only 2 pages of the 4-page pleading were emailed. Other than it being an Adobe PDF, no other provisions of Rule 5.02 were met in this case. And simply put, if Rule 5 is not complied with, then service has not been made. And in this case, it was unequivocally out of compliance with Rule 5.02. None of the requirements of the rule were met. One email was sent. It was an incomplete copy of the pleading. It did come into my email inbox. We addressed this to the court below. Unfortunately, I was out of the office that day at a dispositive motion hearing in Weakley County. I don't know if I clicked it on my phone and it moved it out of the unread mail, but for whatever reason, I didn't see or realize that I'd received that email. Now, the email didn't include language in the subject line referencing service of the pleading. It was not followed by any kind of hard copy certificate advising that any kind of pleading had been served. And I was simply unaware that it existed until August the 10th, the afternoon of August the 10th. I was finally copied on an email to the court clerk asking whether or not the hearing was still scheduled to go forward in the morning. I contacted opposing counsel. She acknowledged that she didn't mail a copy of it. She forwarded me the email that she sent, and I've attached an affidavit to the pleadings that are in the trial court record explaining that was never sent by hard copy, that she acknowledged that was the only email that was sent, and even the email was an incomplete copy of the motion. It omitted the last 2 pages, notably including the notice of hearing. So ultimately, the motion that was granted dismissing this case with prejudice was never served under the rules, and a notice of hearing was never served under the rules. So it was not properly served, and it was not noticed for hearing. Despite that, the trial court went forward with a hearing and ultimately granted the motion over the plaintiff's objection.
Let me ask you about that order granting the motion to dismiss. This is the order of August the 18th of 2020. It's signed by the judge and Ms. Hill. Your signature's not on it, and I don't see a certificate of service.
I agree with that, Your Honor, and that I didn't sign the order. Certainly, I didn't agree with the terms of the language that was used in the order. Most notably, the order that was ultimately entered doesn't address any of the arguments that were raised or I'm sorry, I'm conflating the 2 orders, but no, it was an email copy was sent to me, and I may be misremembering, but I thought it did have a certificate of service on it. But the certificate of service referenced an email that was sent to me of the proposed order, the original order of August 18th.
Are you aware of a certificate of service in the record here?
I could thumb through it and find it quickly, Your Honor, but I do recall that there was a certificate of service. We discussed that in the hearing. The certificate of service, though, said that it was served by email, but the date that was referenced in that certificate of service, and again, with limited time, I don't want to dig through all the paperwork, but the date that was referenced in the certificate of service was the date that she emailed me a proposed copy and said, hey, here's the proposed copy of the order, whether or not you agree. I didn't agree with the terms of it and didn't sign off on it. And actually, I non-suited the case on August the 13th of 2020, which was 5 days before the dismissal was entered. And so,
let's just clarify that. So, are you saying that the order that was emailed to you was not the order that had been signed by the court?
No, sir. Your Honor, the only copy of that order that was emailed to me was the proposed order that Ms. Hill sent to the court. I was copied on it when it went to the court by email. Again, not proper service of that. But by that point, I'd already voluntarily dismissed the case 5 days prior.
I understand. But what my question is, what I was asking you about was the actual order that was signed by the judge and Ms. Hill, and I don't see a certificate of service on that order, on the actual order.
No, sir, it was not served under the rules. It wasn't served under Rule 5. It wasn't mailed to me. It was emailed to the judge's assistant. I was copied on that email, but no, if there was a certificate of service on that, it not valid because no formal service was ever made of that order.
So the certificate of service you're talking about is on a proposed order.
Yes, Your Honor.
All
And
right.
again, there's three different orders that kind of play in, and I may be discussing the wrong one. But again, running a little bit short on time, so just briefly.
Go ahead. Go ahead.
Yes, sir. One of the main reasons that the order was granted was the court found that the plaintiff had failed to comply with the terms of a previous order that was entered June 9th. And that order, and I've explained some of the issues with it more in my briefing that I've set forth, but it ultimately ordered the plaintiff to produce certain evidence for inspection, despite the fact that no formal discovery request for that inspection had ever been made. That order followed by a little over a month, a telephone conference that we'd had with Judge Allen. And I did not recall him ordering the plaintiff to come forward with dates and coordinate the discovery inspection that the defendant wanted to complete. Ms. Hill ultimately drafted a copy of that order and mailed it to the court ex parte. I was sent a proposed copy of it some weeks before. I didn't agree with it because I didn't think it reflected what the court had done. I didn't approve the order. It was ultimately sent to the court without my knowledge. I was not copied on the mailing. I wasn't copied on any correspondence that went to Judge Allen, but it did have a certificate of service on it. But that certificate of service referenced the proposed order that had been emailed to me, weeks earlier or days earlier at least. So Judge Allen ultimately entered that order, and I had no idea that it had even been sent to the court for entry. So that is ultimately the reason I didn't comply with the June 9th order. It was simply that I didn't know it existed or had been submitted for entry or had been entered into the record. So that's the second reason that the order of dismissal was improper. And the third, with respect to the order of dismissal, again, I non-suited this case before the order of dismissal was ever entered. And there are lines of cases that deal with the ability of a party to file a voluntary non-suit after a hearing has taken place. And there's been a recent case, 2021, Urban versus Green, where they lay it out fairly clearly. It originates with Hamilton versus Cook, which was several years earlier. But if you submit a motion to the court on the merits and the court rules on it, if it's time barred by statute of limitations, or if there's a motion for summary judgment where you've established that the defendant can't prove their case, something to that effect, and the court rules on it and rules that he's going to dismiss the case, then the courts have treated that as essentially analogous to a bench trial where the case has been submitted to the court for determination on the merits. At that point, the plaintiff no longer has a right to non-suit. If it's submitted to the court for some other grounds, procedural grounds or otherwise, that rule simply doesn't apply. Under Rule 41.01, it delineates exactly when you can take a voluntary dismissal. And nothing in that rule prohibits a voluntary dismissal under the facts of this case, which is a procedural motion that had a lot of issues with it in its own right, but a procedural motion which was purportedly for failure to prosecute, having the court orally stating that he was going to grant the motion. And then I voluntarily non-suit the case. That's a valid non-suit, and the court can't disallow it under Supreme Court precedent. But that's exactly what happened in this case. He ignored the voluntary non-suit and signed the order dismissing the case with prejudice. So for those three reasons, we think the order of dismissal was improper. I'm out of time, so I'll have to rely on the briefing with respect to the order motion to set aside. But if there are any questions, I'm happy to address them.
You'll have your rebuttal time.
Yes, sir.
All right. Any questions? All right. Ms. Hill?
Thank you, Your Honor.
You may proceed.
Thank you, Your Honor. This is Tamara Hill. I'm representing the defendant, Jason Usery. May it please the court. A lot of blame has been cast on defendant, but the real issues are, number one, that plaintiff's claims were dismissed for failure to prosecute. And number two, does a trial court have to suspend proceedings for all other cases before it and race to fashion a written order before a plaintiff who never asked for a voluntary dismissal prior to the ruling, walks from the courtroom to the clerk and files a notice of voluntary dismissal to avoid a dismissal with prejudice for failure to prosecute? The plaintiff never sent discovery and made only one attempt to depose the defendant, and that was on the eve of depositions defendant had requested 2 months prior. Plaintiff canceled all depositions because defendant was not available on the one and only date plaintiff dictated. The purpose of the Tennessee Rules of Civil Procedure is just, speedy, and inexpensive resolution of matters before the court. Attorneys have a duty to their clients to avoid needless expense, and the local rules require cooperation. As set out in the brief, plaintiff has demonstrably refused to cooperate with defendant at every turn. His entire appeal is based on accusations of failure to use technical methods that increase litigation costs to combat his own refusal to cooperate. The bottom line is that the trial court dismissed plaintiff claims for failure to prosecute. As much as plaintiff would like the court to blame defendant, it is plaintiff's burden to prosecute his claim. The trial court rendered its decision exactly 3 years after the complaint was filed. Defense counsel was to draw the order based on the court's oral ruling, including its reasons therefor. That was done and sent to plaintiff for approval the same day. Once again, plaintiff elected not to cooperate. And as far as plaintiff not agreeing with the order and not approving it, there was never any response. So I guess we can take that as not approving it. Ignoring the order, plaintiff fashioned a notice, an order of voluntary dismissal, and drove it from Jackson, Tennessee to Lexington, Tennessee. However, the trial court's primary office is in Jackson. Thus, the order of dismissal with prejudice reached the court prior to the notice of voluntary dismissal. The court's decision was legitimate, reasonable, and discretionary and should not be overturned. To do so creates chaos and confusion, along with disruption of the docket, as it puts the court in a race for time against the plaintiff whose case it has dismissed. Respectfully, the trial court should be affirmed. As far as Rule 502 goes, it is true that we did not mail the motion itself, but the rule requires a letter telling them what the motion is, how many pages it is, and our standard office practice is to do that and to offer to send them another copy if they didn't get it all. And the proposed order was the order. The order, as an attorney, I never presume that the order that I'm drafting will be exactly what the court wants. So it's always entitled proposed. It's sent to opposing counsel and it's sent to the court. And the court can either make changes, mark that out, whatever it needs to do to make sure the order reflects exactly what the court had decided. I didn't have the transcript to be able to make sure it was perfect. That's why it was proposed. But we've not gotten a response to any of our emails, orders. And that's really all I have to say, Your Honors. I mean, the brief speaks for itself. The timeline speaks for itself. It was 3 years, and the court had to actually call up the parties in April of 2020 and demand a status conference because nothing had happened since November of 2018. And for the court for a plaintiff to have actual knowledge that the court has said, you need to provide these dates, you need to let them see this place where you have moved these things, and there's no address, you need to make arrangements for them to do that. And that's been going on since December of 2017, and it's never done. It's just disingenuous to say, well, defendant had to file a formal motion and increase expenses because even though I know the court told me to do it, I'm not going to do it unless they file this other formal motion. And the practice of law is not supposed to be like that. The local rules require cooperation. It just basically the trial court has the ability to control its docket. It gave the plaintiff 3 years. Plaintiff did nothing. So the case was dismissed for failure to prosecute, which is something the court could do sua sponte. That's all I have, Your Honor.
Any questions? Thank you, Ms. Hill. Mr. Nelson, you have your rebuttal time.
Yes, sir. I would point out that none of Ms. Hill's argument and none of her briefing actually addressed the legal issues that had been raised on appeal. We could go down the rabbit hole of what we did or what we didn't do. I can concede that I didn't move the case as expeditiously as I should have in this case, but that's not the issue on appeal. The issue on appeal is whether the court can properly grant a motion to dismiss with prejudice, granting a motion to dismiss that was filed by the defendant, where that motion has not been served on the adverse party. And Ms. Hill makes it sound like I'm asking her to jump through tons of hoops and make formal. All I'm asking is that she follow the rules that everybody else is required to follow. Ultimately, I had to show up on August the 11th, which was the date that we'd already scheduled for a status hearing in person, and defend a motion to dismiss that I'd learned of less than 12 hours earlier because it was not properly served under the rules. That violates the rules of civil procedure, certainly, but the rules of civil procedure are there to ensure fairness, to ensure due process. And if Ms. Hill, if what she did in this case is allowed, if a party is allowed to file a motion with the court, not serve it on the other party, notice it with the court, but not serve a copy of the notice of hearing, show up on the date and get it dismissed with prejudice, there's obvious implications to that for the practice of law, for the general concept of civil litigation. It can't go forward in that way. The rules are there for a reason. The rules are not suggestive. The rules are mandatory. Rule 5.02 requires service in a very particular way if you want to serve it by email. Now, Ms. Hill said that, well, our office practice is to mail out a certificate. That may have been their office practice, but it wasn't met in this case. I've submitted an affidavit that's in the record that sets forth that we never received anything. We never received any other notice. When I spoke to Ms. Hill on the 10th, when I first learned of the motion that was scheduled the next day, I asked her, did you mail it? Did you mail anything? The email is all that she has. Now, if there was another document that was sent, if there was an email that was in compliance with Rule 5.02, all she has to do is provide a copy of it. I've asked for that before we even filed the appeal. To my knowledge, it doesn't exist. And certainly I never received it. If it does exist, it was simply lost in the shuffle somewhere along the lines. But with respect to the voluntary dismissal, she asked if the court has to suspend proceeding. No, but the precedent in Tennessee is abundantly clear. The court speaks through its written orders. An oral ruling indicates what the court is going to do, but the court does it by signing a written order, recording that in the trial court's record. So until the court actually entered an order dismissing the case had not been dismissed. It had not been submitted for the determination on the merits. It was a procedural argument that the Tennessee Supreme Court has been very clear is strongly disfavored in Tennessee. Motions to dismiss for failure to prosecute or like default judgments, it runs against the general idea that we want cases to be decided on their merits. In this case, it was dismissed without prejudice or with prejudice on that procedural ground, which runs counter to the court's preference and the judicial system's preference. And it was done without even service of a copy of the motion that was granted. So, Your Honor, there are numerous reasons that there's procedural flaws and various issues with respect to this dismissal, and we would ask the court to reverse that dismissal and allow us to pursue this on the merits.
All right. Thank you, counsel, for your argument. We will get you a decision as soon as possible.
Thank you, Your Honor.
Y'all are free to
Thank you.
go.
Thank
Thank
you.
you, Your Honor.
Good day.
Thank you.
This honorable court is in recess.